Hi there, you're with BQ Prime, and this is the fine print, and we're covering extensively the personal data protection bill that the government notified on Friday. Now, we've looked at what the civil society had to say. We've looked at what it will do for users like you and me. And I'm joined by Cyril Shroff to understand how should businesses prepare for the workings of this bill. Mr. Shroff, welcome to the fine print. Before I come to the specifics, your quick sort of first comment on what the 24 pages sort of seemed like to you in the first glance, and also did it seem like a comprehensive piece of legislation to you?
So quick comments to answer your question is glad it's finally here. It's simple, progressive, and I think the most important thing is that we are moving ahead. I think it will also given its simplicity, I think you will see it go through Parliament also quite quickly. That's my guess. So to answer your second part of your question, is it comprehensive? I would say mostly yes, but there are two or three kind of nuances to that. Nuance one, I think, whilst it's covers a lot of ground on personal data, it has completely omitted non-personal data, which was a big part of the previous version of the bill. So to that extent, there is a boundary line around comprehensive, as you call it. The second comment I would have is that a lot has been left to delegated legislation and to rules. So note of caution here that we have to be careful about excessive delegation, and that when those rules and frameworks are created, that there are adequate norms and there is accountability, and it doesn't become kind of a Wild West type of situation. I think they will be careful because they've obviously applied their mind a lot, and this is a deeply thought out approach that has come. So I think that would be my take. There is a reason, whilst it's short, there is also a reasonable amount of detail on some of the key concepts.
Sure.
Final observation is that it has moved away considerably from GDPR. The earlier versions were very GDPR oriented. This, I think, is India is charting a path of its own, and it may well be that this becomes the model for many economies.
Okay, let's try and get into the specifics, Mr. Shroff, and what you've been able to glean in terms of implications. What they're saying is that any processing of digital personal data within India, where personal data is collected from data principals online or it's collected offline and is digitized, is going to get covered. But other industries, do you believe that probably process data of non-resident Indians, let's say our BPO industry, where let's say we don't give those digital protection or rather data protection rights to sort of people who are whose data is getting processed by Indian entities outside of India?
Yeah, I think there are two parts to it, of data from folks outside being processed in India and kind of vice versa as well. I think there is that element of how are we going to deal with transfer of data. Let me come to the latter portion because it's also kind of linked with the data localization issue, which you will probably raise shortly. So my take on this is that it's good that we have moved away from hard data localization, as was the sort of previous version. However, I mean, and this is still non-obvious, but I think people need to understand it, is that there are two principles here. One is transfer of data is actually forbidden. You can't transfer data out except, and that is where the gateway comes in, is where you are transferring data subject to the framework created for trusted countries or trusted markets. So the basic rule is that there is a wall, and to get through the wall, you have to go through the openings created for trusted. And how that, what is a trusted country and what's a trusted market, that is yet to be seen. So that is kind of, and I think it's a practical fix. I also see it as where kind of geopolitics meets technology meets national interest. So that's part. That's as far as the Indian data going out. And I think the latter part about foreign data or non-Indian data coming in is concerned, I think it will have to be based on a consent-based regime, based on the applicable data protection laws in those countries. And once the data is over here, I expect once the final version comes out, post the consent period, that it would be protected.
Okay,
Otherwise,
so
it
it's
would
a
create,
language fix
it
that you
would create
believe.
yeah. Otherwise, it would create a very odd framework where in a common data pool that you have these sort of mixed parts of protected data and unprotected data. That cannot be the intention.
Yeah. So you believe that it's a language fix and it will happen.
Whether language fix or drafting fix, whatever it is, I think it will happen.
Okay, all right. So let me also now, of course, take the data localization that perturbed a large set of industry and businesses. And a lot of people have commented that, the lobbying efforts have yielded fruit. You don't have to now, have in India mandatorily, or have, let's say, a mirror copy, all those concepts that got sort of floated in as part of the Justice Sri Krishna committee and were also there, let's say, in some of the later versions. Now, what we have is essentially one line, Mr. Shroff, that look, we will notify some friendly countries based on certain criteria, and you'll be allowed to store data there. How helpful is this? As you said that maybe it's a good balance, but how do you believe that this will practically pan out?
So here we are talking headlines. As you said, it's one sentence,
Yeah.
but we can visualize conceptually what this means. So I think there will be various categories of countries, but at the extreme it is trusted, not trusted. And friends of India who have a good regime will be in the trusted category, and kind of vice versa. So it's a new approach of how to think about it. Reciprocity will definitely be one part of it, as well as I think there will be some thinking as it go along on, okay, so what's in it for India? And because we've developed this theory over the last several years that data is the new oil, and we are sitting on 1.4 billion units of oil, and growing. So I don't think national interest will be compromised, but we have probably taken a middle path of staying away from the two extremities of hard localization. We are not letting anything go. There was a lot of pushback from global multinationals and other markets. So this is a kind of a middle ground. Remember also one thing, that this we're only talking of the PDP Act. There will be separate regulations by RBI or SEBI or IRD and others, which may have their own requirements on this as well. So as the minister said, that it is horizontal, it's a horizontal legislation, and it is both sector and technology agnostic. So who knows, some of these things may come up in a different form, say for the financial services industry or the e-commerce industry. This legislation is not the sole source of truth for this law.
I get that, but just to sort of understand that when you're saying that there would be reciprocity conditions, there would be.
I'm
Will it,
imagining.
yeah, will it sort of shake the existing models too much? Because right now industry doesn't know what to expect, and I mean, I'm just trying to understand what is it that they should be prepared for.
So we are speculating over here, but I think it will definitely be, there'll be some big changes. It can't be status quo. That would be too naive to expect.
Okay, let me come to one aspect which has sort of gotten that distinction that existed. Let me put it this way, has now been taken away, and I want to understand from you the implications of that, which is that we had a distinction of personal data and sensitive personal data, and there were sort of additional requirements that, as data fiduciary, you were required to do when you're dealing with sensitive personal data. What do you believe would be the consequences of doing away with that distinction?
So this is a nuance, and I'm unable to assess at this stage whether it's intentional, or it is something which is meant to be covered in the rules. But in wearing my lawyerly hat, I think we'll have to have some distinction legislatively. There are clearly two types of data, personal and sensitive, and earlier there was a concept of critical
Yeah.
data as well. But leave that excessive distinction aside for a second. The purpose of these categorizations is that you want a more stringent notice and a higher penalty. That would typically be the reason, because sensitive data and data breaches relating to that would carry different consequences. So if you're going to have a higher standard for sensitive personal data, the foundation of that will have to be legislation. I think it is too big a risk to take of having that foundation in only on rules, because the moment somebody is charged with a higher penalty, they are going to be very motivated to challenge it in a court of law. So, in order to obviate those highly avoidable challenges, I think I expect after consultation and in the final law, you might see some guidance on this. But let's see how they are thinking. But if I was a draftsman, I would have had this distinction in the legislation, not delegated down to the rules, because it's a risk.
Sure. Let's try and sort of now understand, Mr. Shroff, that what does it really mean for businesses? Uh, Help me that through this 5-year consultation process, what is some of the apprehensions, let's say, your clients had shared with you? And then I'll come to whether, those get addressed or those get, let's say, successfully, if I can use that word, get lobbied in this shape and form that the bill is in.
So there are multiple stakeholders in this, and the most important stakeholder in this is the person to whom the data belongs. That's the data principle, or as they now call it, the digital Nagrik. Let's look at it from their point of view. So the journey started, as you know, with the Supreme Court judgment by Justice Chandrachud in the Puttaswamy case, where the right to privacy was recognized as a fundamental right, and that the government was requested to come up with a suitable data protection legislation. And we've seen that over the last few years how various iterations have happened. So coming to me, using that as a starting point, I think let's look at it broadly from the point of view of the relevant stakeholders. As far as the citizen or the digital Nagrik is concerned, this is a big step. It's not a perfect step, because there could have been more details that could have been showcased, but we are moving from a regime of a complete lack of a credible data protection law to at least something which is decent. And that's a big step, and I think we must be the only major economy in the world which does not have a data protection law. So I think that's a tick over there. Now look at it from the point of view of those who collect the data, the data fiduciaries, and the processors of data as well. Personally, the more mature ones would take a view it is that it is better to have a, uh, a framework and an enforcement mechanism than have it in a completely unregulated form. So whilst there would be quibbles about this clause, that clause, the penalties are too high, etc., etc. Fundamentally, I think the industry which should welcome this as a progress, because it creates a base for uh, you know collecting data, and innovation can be based upon it. An completely unregulated situation can never be good for development or progress. So this creates a baseline, and I think therefore that most of the concerns are addressed.
Okay, so
There will be a lot of pushback on some parts of it, but that's okay. That will
okay,
happen whichever version you come up with.
yeah, so I'll come to where do you think the pushback is possible. There's this now new sort of concept of significant data fiduciary. And I mean, this is the first version we've seen this in, probably borrowed from what we have in terms of significant social media intermediaries in the digital intermediary rules. Now, based on a set of criteria, the government says by notification, we will tell you who the significant data fiduciary is, and they will have a more onerous set of requirements that they'll need to fulfill. Uh, do you believe that that's the right step, that you legislate the ones that are likely to have the more, or rather you strongly legislate the ones that are likely to have more impact? And again, in terms of preparedness, what should businesses be looking at?
So there will be players of various shapes, sizes, and complexity. Even if you take by analogy the NBFC sector, you have NBFCs and you have systemically important ones, and it's a function of size, scope, and coverage. So conceptually, personally, I don't see a problem with the fact that there is this distinction that has been made, and it allows for proportionate regulation. Because if you did not have this distinction, you would have had the problem of the small guy and the very big guy are subject to the same rules, and that can't be right.
Yeah.
So this allows for proportionate regulation without creating unnecessary anomalies. And you have to look at it also from the point of view of startups, or smaller firms which may not have the technological infrastructure or the skills to do it. So it creates a more light touch a regime for them. So I think this is logical.
Okay. And in terms of, let's say, the existing players that probably can glean from the parameters that have been laid down, let's say in terms of the volume of data, in terms of the kind of data that you're dealing with, or the data that can impact the electorate, any immediate steps you think that this bill requires them to take?
So I think there's a lot of rules to be made in this, and I think even before we get to that stage, in the consultation period and before it goes to Parliament, I think there are areas which require to be clarified. For example, the concept of purpose. I think that otherwise you take the risk of it evolving in a sort of uncontrolled way. Some legislative guidelines or signals I think are required before we get to that stage. But when you compare it with a very heavy duty, extremely detailed GDPR-ish version to a more principle-based, simpler approach, which you're going to evolve as we go along, I think for India at this point of time, the approach that we have taken makes more political sense.
Okay. And when you say that there are parts of the bill where you anticipate there'll be pushback, do you want to sort of identify some of those areas?
So, as a firm, we would be sort of representing a number of clients. So I don't want to get too ahead of myself on, how that would land. But just a few topics which I think kind of are more common sense. I think uh, you will have some pushback on the itemized consent. When instead of aggregate consent, if it's not like you have a drop down list of 20 items and you have to click every box, you're going to get into consent fatigue. I expect a pushback on that one. I think you will also see pushback on the level of the penalties. Some of the penalties go up to 200 crores and all that. Now, it's better than like a CCI type regime where it's a percentage of turnover. So there is at least a cap. But these are not small amounts. And some of these could be, for even mid-sized breaches. It's a discretionary uh, area where you will need much more clarity in terms of how these penalties will be administered. So that's another area where I see a problem. I think there will be a lot of discussion around what is a trusted jurisdiction for the reciprocity of transfer. So on the one hand, you'll have the big Western economies, your US, UK, or European ones, and then there will be kind of Asia, and there also you will have friendly and non-friendly nations. But the internet is a global space. I think there is going to be a lot of clarity required in terms of how you are going to monitor it. You can't say a piece of data which goes from here to a trusted country, that it will not travel to China. How are you going to regulate all those further movements of data as well? So I don't know how technology or the technological safeguards are actually going to work out to monitor all this. Maybe somebody else has the answer for this.
How do you think that industry will take to that? Look, every time there's a data breach, you have to inform the data principal. Practically, how sort of uh, burdensome, let's say, compliance-wise, this seems to you, or the larger ones will figure out that this needs to be
I
done?
think there's going to be large capex requirements, particularly for the bigger players. I think significant investment over there. I think there is a skill shortage as well, because there are not enough professionals who need to do this. Uh, and I mean, literally, I think I can imagine that professionals in the tens of thousands are going to be required for staffing these positions. A lot of it will be legal as well, because somebody has to apply this law. It's not just technology, but also the legal and policy and compliance implications of this. So, industry, I think, will initially be a bit shocked by the amount of investment and the impact of this, but it will find a new normal. I think every market, for example, going back a few years when GDPR came, every company in Europe was moaning about the owner's requirement. But it's all right now. Everybody's kind of found their normal. There's no escape.
Yeah. Have you, I'm not sure to what extent you've sort of, looked at the exemption clause. And one of them is that the government will or can, by notification, identify a set of data fiduciaries or single data fiduciary that will not have to sort of abide by, or some of the provisions might not be applicable. And one of them is that you don't have to give, let's say, inform or get that itemized consent. Another one is that you don't have to actively delete if that purpose or legitimate legal or business purpose is over. You don't have to mandatorily delete that data of that data principal. Where do you think that this is coming from?
So I saw it, and I think this is going to be very contentious, and it's going to be a difficult balance to find. I'm hoping that through the consultation period, we'll see more clarity come out. But this is, I think, a combination of national security, geopolitical interests, all of that. So it's kind of the government has kept a trump card in its back pocket, which it can play multiple times as needed for this. So, from a sovereign and geopolitical point of view, I can see why they need it, but this is going to be a problematic space.
So you're
For
saying that these are probably private entities that the government ends up working with, and those might get exempted from some of the provisions of the law.
Yeah, in order to make sure that this doesn't run away as being excessive, there had to be a lot of guidelines in terms of and safeguards on how this is implemented. So this is going to be one of the more controversial parts of, but we'll see how it comes, and the consultation will provide some clarity. So what we're talking about is only, talking about today is only the first version of it. There's still the public comment till 17 December, and then there'll be another version which will go through Parliament.
Sure. All right, Mr. Shroff, thank you for your initial thoughts on some of these provisions. And of course, we'll keep coming back to you as more consultations happen, and also more notifications where I'm guessing the meat of this statute will be. Thank you for finding the time to speak to BQ Prime, and thank you so much for watching.
Thank you. Thank you.